Welcome back to chapter one. This is part two of the chapter, and we will finish up the chapter in this part. In part one, we learned, and I hope I drove home the point enough, about the reason why we have a federalist type government and why we have all these protections to prevent a central government from being too powerful. And of course, we had that because we had just been through the experience with England and saw the damage, what a powerful central government can do. So we devised the federalist system where one territory is governed by two governments. In our case, it's the federal government and the state government. And after we finished the Constitution and it was ratified, we still felt that there was not enough protection in the Constitution. And in particular, we felt there was not enough protection for personal rights. We had a lot of protection as far as allowing the federal government from becoming too powerful and to give the states the most power. But we really didn't have anything in there as far as our personal liberties. How do we protect our personal liberties from the government? And we do that with the Bill of Rights. And the Bill of Rights is all about securing our liberties. And what are the Bill of Rights? They are the first 10 amendments to the Constitution. And they're called amendments because the Constitution was completed and we added to the Constitution, or we amended it with our amendments. And the first 10 amendments are called the Bill of Rights. Some say the first 8 amendments are the Bill of Rights. And for me, or testing purposes, it does not matter if you say 8 or 10, first 8 or the first 10. I understand, what you mean. So we passed these amendments and they went into effect in 1791. And again, these were designed now to protect us personally from the government. We wanted to build in protections so that the government cannot violate or take away our personal liberties and whatever those liberties are that we have defined in the first 8 or 10 amendments. This is an important point and something you will be tested on, is that the Bill of Rights do not protect us against each other. They only protect us from the government. So a person, a citizen, cannot violate your freedom of speech. That's just impossible. They cannot violate your First Amendment right of speech. Now, we can pass laws, but they would be breaking the law, not violating your constitutional rights. The only ones that can violate somebody's constitutional rights is the government. So these Bill of Rights, these personal liberties, protect us from the government. They don't protect us from each other. Laws protect us from each other. These are the Bill of Rights. I have 10 up here. And for this course, we are going to concentrate on the First Amendment, the Fourth Amendment, the Fifth, and a little bit of the Sixth Amendment. Next chapter is all about the First Amendment, which is the freedom of religion, speech, press, assembly, and petition. In particular, we are going to concentrate on freedom of speech next chapter. The Fourth Amendment is about our right not to be unreasonably searched or seized. We had just gone through that with England, where England was seizing us and searching our properties without a warrant. So we decided to make an amendment to prohibit the government from doing that to us unless it was reasonable. And the Fifth Amendment and the Sixth Amendment we'll get into later on in the semester. We will spend probably most of our time this semester on the Fourth Amendment. The next chapter will be the First Amendment. Then we'll get into the Fourth Amendment for a good period of time, chapters 3 and 4. And then we'll look into the Fifth Amendment and a little bit of the Sixth Amendment. So these are the Bill of Rights. And again, they protect us from the government. They do not protect us from each other. So you cannot violate somebody else's Fourth Amendment right from an unreasonable search. You may be committing a crime, but you're not violating their Fourth Amendment rights. Only the government can do that. Well, the Bill of Rights in the states. The Bill of Rights originally only applied to the federal government because it was the federal constitution. So initially, for many years, the Bill of Rights only applied to the federal government, meaning the federal government could not violate your Bill of Rights or any of those amendments, but the states could. And because of that problem, we created the 14th Amendment. And we'll spend a lot of time on the 14th Amendment from here on out for the rest of this chapter. And the Fourth Amendment states that, or it forbids the states to deprive any person of life, liberty, or property without due process of law. The United States Supreme Court has interpreted this language in the 14th Amendment to mean that the Bill of Rights also protect us from states, not just the federal government. So the Bill of Rights do now protect us from states as well as the federal government. So let's talk about due process. And due process is in the 14th Amendment. And due process, the 14th Amendment, like the other Bill of Rights, like the first 10 amendments, protects people from state action. It does not protect people from citizen versus citizen. So the citizen cannot violate your 14th Amendment due process rights. Only the state or the federal government can. So it protects us from state action. And by state, we mean either a state or a federal government. And this was driven home by the DeShaney case. And if you're going to do the bonus question number 1, then this will be particularly relevant to that question. In DeShaney is really a tragic case. There was a 4-year-old boy living with his father. And DCYF knew that the father had abused the boy in the past. So DCYF is a state agency, Department of Children, Youth, and Families. It's a state agency. So the state knew that this father was abusing the boy, but they didn't take any measures to remove the boy or to protect him. They allowed him to stay here. And then unfortunately, the father brutally beat the boy and left him with permanent brain damage. And the mother and the boy's estate sued DCYF, again, a state agency, so they were suing the state for failing to protect him from his father, depriving her son of due process. This was the lawsuit, was that they were claiming, his mother was claiming that under the 14th Amendment of due process, the state must protect him from his father because they knew that this was happening. They had prior knowledge that the father was beating the boy, and because they knew it, they failed to protect him. Therefore, they deprived their son of due process. Here's the kicker, is that the U.S. Supreme Court said, as tragic as this case is, that the state did not violate the boy's due process rights, because the 14th Amendment does not protect people from actions of other people. And the state, DCYF, they didn't do anything to the boy. They just failed to take him out of that situation. And the court further ruled it also does not require the state to take helpful or protective action. So even though DCYF knew this boy was in jeopardy and they did not take any action, under the 14th Amendment due process, the state did not violate his rights, because the 14th Amendment does not require the state to take helpful or protective action. And quite often, decisions are made at the Supreme Court that don't seem right because of the facts of the situation. But we have to get past that. And this was a tragedy, a tragic story, but we really can't let that affect our judgment and what is right and what is wrong as far as when it comes to legal issues. And the legal issue was, did the state have to act according to the 14th Amendment? And the court said no, that it does not require the state to take helpful action or protective action. And the reason being is that the boy was not in DCYF custody. So if he was in DCYF custody and then the state did not take any action to protect him, now that would be different, because now he's in their custody and they have a duty now under the 14th Amendment to protect him. But he was not in their custody, so the 14th Amendment did not apply. And that brings us to due process itself, and to talk about due process for a little bit. There are two types of due process. When the government takes action against us, they must do so with due process. So if you remember, the 14th Amendment says the state cannot deprive us of life, liberty, or property without due process. So if the state does one of those things, takes away a liberty of ours, takes away property, or takes our life, they must do so with due process. It doesn't say that they can never do it. It just says when they do it, they must do so with due process. So in a word, due process means fair. What due process is all about? It's about fairness. It's about when the government is taking action against us, that they do so in a fair way. If it's not fair, then they violated due process, and it's a violation of our constitutional rights. The two types of due process are procedural due process and substantive due process. So let's take a look at each one of these individually. Procedural due process and substantive due process. First one we're going to look at is procedural due process, which means fair procedures, kind of like what it sounds like. Procedural due process. That means fair procedures. And then we have substantive due process, which means adequate justification. It means that there must be a good enough reason for the government taking away either our life, liberty, or property. We'll get into each one of these individually. So let's go to procedural due process first. Again, it means fair procedures must be used when the government takes any action that deprives a person of life, liberty, or property. That's what procedural due process is. Fair procedures. If they're going to deprive us of one of these rights, the way they deprive us of that right must be fair. It's fair procedures. So examples: notice, cross-examine of a witness beyond a reasonable doubt to be convicted of a crime. So if the government is trying to put us in jail, that means they're trying to deprive us of our liberty. And in order for that process to be fair, in order for the trial to be fair, these are some of the procedural due process. We have a right to cross-examine a witness. The state must prove beyond a reasonable doubt that you committed that crime. And these are just a very small list of a very long list of procedural due processes. So it's the procedures that the state uses when they want to deprive us of life, liberty, or property. And that's procedural due process. It's the process, the fair process the government must use. And then we have substantive due process. And it means an adequate justification for depriving someone of their life, liberty, or property. So not only the way they deprive somebody of their life, liberty, or property, but also why they're doing it. So substantive due process is the why. Why are you doing it? Procedural due process is the way they do it, must be fair. Substantive due process is why. And the why is it a good enough reason? It must be a good enough reason to take somebody's life, liberty, or property. Now, an extreme example would be if you got sentenced to death because you were caught driving while intoxicated and nobody died. Is that a good enough reason to take somebody's life? Obviously, no. Now, that's an extreme example, but you can see where when the government wants to deprive us of something, life, liberty, or property, that it must be a good enough reason to do it. And substantive due process is broken down into two categories. The first is to protect our fundamental rights, and the other is to hold government officials accountable for egregious conduct. These are the two types of substantive due process. So the first one, to protect fundamental rights. Under that, some rights are so fundamental that they cannot be denied without a compelling reason. So it doesn't say that the government can never take away our fundamental rights. It just says if they do, they must need a compelling reason. And a compelling reason is a really high standard for the government. It means a really, really good reason. And usually it's a standard that the government has a very difficult time showing. For example, the right to marry, the right to have children, birth control, healthcare decisions. If the government is going to deprive us of any of these rights, then they must show by a compelling reason why they are depriving us of the right to marry, the right to have children. And this can be shown in a case called Lawrence versus Texas. And in Lawrence versus Texas, the police responded to an apartment for an unrelated call. So when they get there, they find two men engaged in sexual activity. And in Texas at the time, Texas had a law that prohibited sodomy. So they charged the two men for violating that law, for engaging in sodomy. And in this case, the two men challenged this law and said this law violates our substantive due process. So now the government had to show a compelling reason why they had the right to prevent two men from engaging in private sexual activity. And the court decided that the law was invalid. They ruled in favor of the two men. And they said that law is no good. the state does not have a good enough reason to get into our bedroom and tell us what kind of sexual acts we can perform. And it said that private sexual conduct cannot be regulated by the government. And this was a huge win for the gay and lesbian community. It was really the first United States Supreme Court that started recognizing rights of gay and lesbian. So it was a huge win for that community, because now the Supreme Court said, and remember, the judicial branch, it's their job to oversee and checks and balances of the executive branch and the legislative branch. And they said that we interpret this law to violate the Constitution. Before I get to egregious public conduct, let me give you an example of when the government can regulate private sexual conduct. If in this case they said that the court has no business being in our bedroom and telling us what two adults can and can't do in their bedroom as far as sexual activity, then why can the government pass a law that prohibits an adult from having sex with a minor? What is the difference there? Well, the difference is, besides it being a minor, the difference is that now the government has a compelling reason. They didn't have a compelling reason to stop two adults from having sex, but they certainly have a compelling reason to stop adults from having sexual intercourse with minors who can't make that judgment yet. In the eyes of the law, they're not old enough to make that judgment of whether they should have sexual conduct. So in the case of adults in private sexual conduct, there was no compelling reason. However, in cases, laws that prohibit adults from having sexual relations with minors, there is a compelling reason. So they can take that private sexual conduct away from us because they met that compelling interest standard. And that brings us to egregious public official conduct. And this will get us back to the DeShaney case. So when somebody is the responsibility of the government. If you remember in the DeShaney case, the young boy was not their responsibility. He wasn't in their custody. So in order for egregious public official conduct to qualify as violating substantive due process, the person that's making that claim must be a ward of the state, like a prisoner, or in DCYF custody. Now, because they're in custody, now the state, under substantive due process in the 14th Amendment, they must take action to protect that person. But the trigger is the person is a ward of the state, like a prisoner. For example, such as not getting a prisoner medical attention when it's needed. So it must be extreme conduct. So if there is a prisoner in their custody and he's having a heart attack and they stand there and they don't do anything, they have violated his substantive due process. That's extreme conduct because he was in their custody. He was a ward of the state. Therefore, they needed to provide him with due process and they failed to do so. So that's due process. And that's under the 14th Amendment. Now, under the 14th Amendment, we also have the Equal Protection Clause. And the 14th Amendment is a very important amendment. A, because it now said that the Bill of Rights applied to the states, but it also provides due process and it also provides what we call Equal Protection Clause. And I'm going to tell you at this point that this class, there are going to be multiple tests. And by test, I don't mean exams that I give you. I mean tests that you need to apply on exams to determine if there's a constitutional violation. There is a bunch of them. So you need to organize your notes so that you have these tests and you can study them that way, because there's a lot of them. It's all going to depend on the right that the person is claiming the state is violating. In Miranda, there's a test to determine if the state violated someone's Miranda rights. There's a test to determine if someone violated somebody's Fourth Amendment rights. What we're going to get into right now are tests to determine if the state violated somebody's equal protection rights. And what is the Equal Protection Clause? Again, it's part of the 14th Amendment. Go back for a second. And it forbids the state to deny any person equal protection of the laws. So the Equal Protection Clause says that, in a very generic sense, the state must treat everybody equally. And if they want to treat somebody differently, then there are tests to determine whether or not the government can do that. And that's what we're going to go over now. So you need to pay close attention to this. You need to take really diligent notes, because you are going to be tested on this material. And these tests are going to be on the exam where you will have to apply them. So first we have this separate but equal doctrine. And in Plessy versus Ferguson, back in the 60s, maybe the late 50s, this Supreme Court case produced what we call the separate but equal doctrine. And it had to do with segregation, meaning at the time, we were segregating white people from black people in schools. And some people challenged that and said, wait a minute, you are treating us differently. You're taking us from where we live and segregating us into a population that we don't want to be. And the Supreme Court at the time, unfortunately, said that doesn't violate the Equal Protection Clause, as long as there are equal facilities are provided to all races. So if we're going to take you from your neighborhood and put all blacks in this school and only blacks in that school and whites in this school, that doesn't violate Equal Protection Clause, because as long as the facilities are equal, as long as in the school that just has minority kids has it's the same facility as far as what they have access to as the non-minority school. And that was the law for many years. And it applied to separate bathrooms, drinking fountain, bus seats. If you're familiar with Rosa Parks, when she challenged the law, when she sat in the front of the bus, when in the South, blacks were required by law to sit in the back of the bus. And she said, that makes no sense to me. I'm a person just like anybody else. I'm going to sit where I want to sit. And it's not the back of the bus. Talk about a brave, brave young woman to do that in the South back, in the late 50s, early 60s. That was an incredibly brave thing to do. Certainly more brave than going and rioting and smashing out store windows. Rosa Parks set the example on how you conduct yourself when you want to change the government. And we will get into that in much greater detail next chapter, the First Amendment. But for purposes right now, this separate but equal doctrine allowed states to separate bathrooms and drinking fountains and bus seats and schools and etc. It was perfectly illegal, the Supreme Court said. But what often happens is that we evolve as a society. And as we evolve as a society, things we thought were okay before, we look at now and say, boy, that's not okay. That violates our morals. And it's the same with the Supreme Court. So quite often the Supreme Court, years later, will take the same issue and now decide we were wrong before. We have evolved as a society, and now we think that what we said before is wrong. And that's what happened in Brown versus Board of Education. In that case, the Supreme Court overturned the Plessy decision and the doctrine called the separate but equal doctrine for public education. So in other words, the United States Supreme Court said, when it comes to public education, the separate but equal doctrine does not apply. We were wrong in Plessy. So Brown versus Board of Education overturned the Plessy decision when it came to separate but equal for public education. So now that after the Brown versus Board of Education, schools could no longer segregate children based on their race. The Supreme Court said that violates our Equal Protection Clause. You're treating them differently, stop it. It violates the 14th Amendment Equal Protection Clause. And this opened the door, and very soon after that, the separate but equal doctrine was gone in all aspects of government imposed barriers. So when it came to separate drinking fountains, bus seats, etc., bathrooms, the separate but equal doctrine soon did not apply to those either. So again, we evolved as a society. We said our behavior before, we have morally grown, and now the separate but equal doctrine is a bunch of crap, and it doesn't apply to anything. So know that the Brown and Board of Education overturned the separate but equal doctrine. So where we stand today with equal protection. This is where you're going to learn a bunch of tests right now. So equal protection means the government must treat persons who are similarly situated alike. However, there are exceptions to this rule. And this class is really all about exceptions to rules. That the government or the Supreme Court comes out with these rules, and now we have to learn the rules and the exception to those rules. And the exceptions are these tests that we apply to determine if the government violated that rule. So the government can treat persons differently if they have a good enough reason. That's where we stand today on the equal protection. We're not saying, or the court's not saying, that the government can never treat people differently. What they're saying is that the government can treat people differently, but if they do, they need to have a good enough reason. Sound familiar with due process, substantive due process? They need a good enough reason. And that's what we're going to learn now. When is it a good enough reason when we treat somebody or a group of people differently? So we're going to focus in on good enough reason. That's what these tests are all about, to determine if the government had a good enough reason. And to determine if the reason is good enough, a court is going to look at two things. And this is how you're going to go through the procedure. If you are given an exam question and you need to determine if the government violated the the Equal Protection Clause, then these are the steps you take. Number one, you determine who is the subject of the different treatment. So you identify who, what group is being treated differently. And then step two, based on who the group is going to determine the level of scrutiny that should apply. And what is level of scrutiny? Level of scrutiny just means the standard that's applied. It depends on the who, will depend on the level of scrutiny that a court is going to look at to determine if the Equal Protection Clause was violated. So there's three levels of scrutiny. The first is what we call low or rational relationship scrutiny. The second is intermediate scrutiny. And the third is strict scrutiny. Depending on the group of people that's being treated differently by the government is going to depend on what level of scrutiny you're going to apply to determine if the Equal Protection Clause is violated. So each level of scrutiny puts a different burden on the government to show justification for its disparity in treatment. So low or rational relationship scrutiny is a pretty low standard. And strict scrutiny is a very high standard for the government. And again, depending on who the group is going to depend on what level of scrutiny we're going to apply. So let's take a look at first, depending on who's being treated differently, will determine which level of scrutiny will be used in determining if the government is violating the Equal Protection Clause. So always, the first thing we do is we look at the who. If you're presented with an exam question about the Equal Protection Clause, the first thing you need to do is who's the group of people that's being treated differently. That's step number one. And based on what you're going to learn next, you will know which level of scrutiny to apply. So the who is going to determine the level of scrutiny. So let's take a look at our first level of scrutiny, what we call the rational relationship scrutiny. It's the lowest level of scrutiny that we have, meaning it's the easiest for the government to prove. If the who qualifies for this rational relationship scrutiny, it's going to be very easy for the government to win that case. So rational relationship is our lowest level of scrutiny. It's the easiest level of scrutiny for the government to meet. And it includes statutory classification that do not involve race, color, nationality, or gender. So if a law prohibits, or if the government is treating a different group of people differently based on their nationality, then it's not going to be rational relationship. If they do it based on religion, it's not going to be rational relationship. So it's statutory classifications that do not involve race, color, nationality, religion, or gender. So what does it involve? The affected class for the rational relationship scrutiny is age. If the government passes a law that affects people because of their age, then the government is only going to have to show a rational relationship. And it's up to the challenger. So I strike that. It's not the government that has to show that. In this case, it's the challenger must show there's no rational relationship to any legitimate government purpose. So you can see that's a pretty low standard for the government. The group has to show that there's no rational relationship at all to what the government is trying to accomplish by treating them differently. For example, in this country, the drinking age is 21. Well, let's go through. So government passes a law that makes the drinking age 21. So you'd be presented with a problem like this. So the government passes a law that makes drinking age 21. So meaning under 21, you cannot drink alcohol. So now you have to determine, can the government do that? So what's the first thing we do? You look at who it affects. Who does it affect? Age. because it's affecting people because of their age, we know that we use the rational or the rational relationship. So you first look at the who, and then you apply the appropriate level of scrutiny. The who is age, and the level of scrutiny is the rational relationship to government purpose. If there is a rational relationship, then it doesn't violate the Equal Protection Clause. If there's not, then it violates the Equal Protection Clause. So in this case, is there a rational relationship for the government to treat those under 21 differently to prevent them from drinking? And the answer to that is yes. There's a rational, because what is the purpose? The government's purpose in that is to save lives, to prevent younger people from drinking and to save lives. So is there a rational relationship between making that law to the goal of saving lives? Yes, there is. So therefore, that law does not violate the Equal Protection Clause. If they said that men cannot drink wine, but women can drink wine, that would have to be a different test, because now it's not age-based. We're basing it on gender. So you have to look at the who. And the who, in this case, is the age. When age applies, then we look at the rational relationship. So what if the law said that Italian Americans cannot drink until age 21? So now you got two different groups. You've got age group under 21, but it's a specific group under the age of 21, and that's Italian Americans. So we would not use, for us to look at the class who it affects Italian Americans. And because it's somebody's nationality, this does not apply. So we would have to use a different test, and we'll get into that later. So the very first thing is look at who the group is. And so far we learned that if the group is strictly just because of their age, we apply the rational relationship scrutiny test. Now let's look at intermediate scrutiny. It's a higher burden for the government to meet. So with the rational relationship, the person challenging the law must show there's no relationship. However, with the intermediate scrutiny, the burden is on the government now to meet this. And the affected class is gender. So all laws that apply to a group of people, or treatment of the government to a group of people differently because of their gender, we're going to use the intermediate scrutiny test, which is the government must show an exceedingly persuasive justification. So if the government is going to show, if the government passes a law or a rule or treats anybody differently, a group of people differently because of their gender, now the government has to show an exceedingly persuasive justification for doing that, which is much more difficult than a rational relationship. For example, the FBI will not hire a man for a job that requires a person to go undercover as a dancer in a gentleman's bar. So again, on a test, you'd be presented a very small scenario like this. And now you see the government's treating a group of people differently. So step number one is we go to who is the class. Who does it affect? Gender. Because it's saying, now don't forget the FBI is a government agency. So they're saying that if somebody's a male, they cannot be hired for this job that requires them to go undercover as a dancer in a gentleman's bar. And now we know who the who is, it's gender. And now what's the appropriate level for the scrutiny? We now know it's if the government can show an exceedingly persuasive justification. Can the government, in this case, show an exceedingly persuasive justification? Yes, they can. Because if they hire a man for a job to be a dancer at a gentleman's club, then obviously that's not going to work. So I think they can show an exceedingly persuasive justification for treating men differently for that job classification than they treat women. So that's intermediate scrutiny. And that brings us to strict scrutiny. And this is the most difficult burden for the government to meet. Very hard. So if the government is going to treat these groups of people differently, then they need to meet strict scrutiny. And it's very difficult for them to do. Can't say they can never do it, but it's just more difficult. So the government must show a compelling reason. So that is higher than an exceedingly persuasive justification, the intermediate test. This is a compelling reason for treating the class of persons different. So compelling reason means it's a very high standard for the government to show, meaning they better have a very, very good reason for doing that. And the affected groups of people, the affected class, are race, color, religion, nationality. So if the government passes a law or treats anybody differently, a group of people differently because of their race, color, religion, or nationality, we are going to use the strict scrutiny test. And we call them suspect class. And we call them suspect class because the way they're being treated is automatically going to be deemed suspected. Very suspicious. Why are we treating that group differently? So we're treating them differently, and automatically a court is going to say that's very suspicious to us. Now, government, now you have to show us a compelling reason why you're treating that suspect class differently. And over here is just how you determine if it's a suspect class. And these are not all the things we look at, but just some of them. So what about sexual orientation? Where do you think sexual orientation should fall? Should sexual orientation be with age, a low rationale? Should it be intermediate along with gender? Or should sexual orientation, does that in your mind qualify as a suspected class? And I think it does. I think it does. The court has not ruled on this yet. The Supreme Court has not made a rule on this yet. Lower courts have, and we're hopeful that the Supreme Court will say that if the government treats somebody or a group of people differently because of their sexual orientation, they better have a compelling reason. So we are hoping that sexual orientation falls into the suspect class because they've been historically been discriminated against, have been the subject of prejudice, hostility, stigma because of stereotypes. So they would fit one of the definitions of suspect class. So hopefully that the United States Supreme Court will determine that suspect class will include sexual orientation, but they have not decided that yet. So just to review, if it's age, it's a rational relationship, and the challenger must show no rational relationship to any government interest. And the hurdle is very low. It's a very easy hurdle for the government to get over when it's age. If they treat a group of people differently because they're gender, then they must provide an exceedingly persuasive justification. It's a difficult hurdle, but not impossible for the government. It's a little higher. This hurdle is a little higher than the age. And then finally, if it's a suspect class, race, religion, nationality, etc., then the government must provide a compelling reason. The hurdle is very difficult for the government, but not impossible. So if it's a suspect class, it's a very high hurdle for the government to overcome, but not impossible. An example would be if the FBI wants to infiltrate the KKK in Fall River, and they say that we are only hiring white people for this job. So automatically it's treating African Americans differently. It's treating minorities differently than it's treating white people. So the who is a minority, somebody's race. But can the government show an exceedingly persuasive justification for doing that? And I think they can, because obviously a person of color is not going to be able to infiltrate the KKK. So that is an example of an exceedingly persuasive justification. But they're few and far in between. Just like this picture shows, it's a very high hurdle for the government to get over. So that's the Equal Protection Clause. Hopefully you took diligent notes. You can always go back on this if I went too fast. You will need to know, you will have to apply these tests on an exam. And the last subject we're going to get into is the judicial branch. So we'll talk about that for a little bit. And just because we have a federalist, a dual government system, we have a dual court system that goes along with it. We have federal court and state court. So we have federal court to handle federal issues, and each state has their own court to handle state issues. And we have the United States Supreme Court, which is a federal court. And that's the highest court in our land. There's no court higher. So if there is a federal constitutional issue, the United States Supreme Court has final say on that issue. So let's just take a look at each system briefly. Each state has its own court system and its own constitution, believe it or not. So we'll get into that in a minute. Let's look at the court system first. This is an atypical state court system. Some states may have it a little different, but in general, this is typical. We have a district court, which is a trial court for a misdemeanor. If you remember from criminal law, a misdemeanor is a crime, it's the less serious crime than a felony. It's less than a year in jail. So if you're charged with a misdemeanor, that case goes to district court. And superior court is the trial court for felonies. If you're charged with a felony, it goes to superior court. And if you're charged with a misdemeanor and you lose and you want to appeal it, you appeal it to superior court. Whenever you appeal, it always goes up. And then we have a state Supreme Court. So not only do we have a federal constitution and 50 separate state constitutions, we have the US Supreme Court, and every state has their own Supreme Court. Now in New York, they reverse it. They call their Supreme Court Superior Court and the Superior Court Supreme Court. I don't know why they do that, they just do. But as far as content, every state has their own state Supreme Court. And what can they hear? They can hear state constitutional and state law issues. So if somebody is claiming that a state law violates the state constitution, then the state Supreme Court is the final decision maker on that. The state Supreme Court, not the federal Supreme Court, because it's a state constitutional issue. If it's purely a state constitutional issue, then the state Supreme Court has final say. The state Supreme Court can also hear federal constitutional issues, but they don't have the final say. The US Supreme Court has the final say on US constitutional issues. So if you feel that the police have violated your federal constitutional issues, you can appeal it to the state Supreme Court. And if you lose, you can appeal it to the US Supreme Court. If you feel the police have violated your state constitutional rights and you lose at the state Supreme Court, it cannot go to the US Supreme Court because it's a state constitutional issue, not a federal constitutional issue. So state Supreme Courts can hear both state constitutional issues and federal constitutional issues. All right, so district courts are the trial court for misdemeanors, superior court, trial court for felonies and appeals court from district, and finally state Supreme Court, state constitutional, state law issues, final decision maker, and can also hear federal constitutional issues, but it's not a final decision. Only the Supreme Court has final decision on US constitutional issues. The Constitution itself, every state has their own constitution. We have the federal constitution, and we have 50 different state constitutions. And they're virtually identical to the federal constitution, almost word for word. At least the first part of it is. And then each state adds their own individual things. But they're virtually identical to the federal constitution. So what that means is that under the state constitution, the state can give you more protection than what the federal constitution can, but they cannot give you less protection than what the federal constitution can. So the federal constitution provides minimum protection. So for example, Fourth Amendment rights. State constitutions have a very, if not identical, Fourth Amendment, as does the federal constitution. They're identical. The US Supreme Court interprets the Fourth Amendment. They may interpret an issue under the federal constitution. The state may interpret that issue, that same exact issue, under their constitution and come up with a different result than the federal court. That result is only valid if what the state determines gives the people more protection than what the federal constitution gives them. So the state may say that even though the federal government thinks that this violates or this does not violate your Fourth Amendment rights, under our Constitution, we think it violates our Fourth Amendment in our Constitution. So the best way I can really show that is by example. The US Supreme Court has ruled that DUI checkpoints do not violate the federal Fourth Amendment in the federal Constitution. They've said that. And a checkpoint is meaning the police can stop you at a checkpoint without any suspicion. Now, normally the Fourth Amendment requires police to have some type of suspicion to detain you. But the Supreme Court has made an exception for DUI checkpoints. And they said that police in every state can have DUI checkpoints, and that doesn't violate our Constitution. We're going to allow that. We've determined that does not violate our Constitution. However, in Rhode Island Supreme Court said, but we think it violates our Fourth Amendment. So we're not going to allow it under our state constitution. Although the federal government said it doesn't violate the federal constitution, the way we read our constitution, we feel it violates our constitution. So we're going to prohibit the police in Rhode Island from conducting DUI checkpoints. So in Rhode Island, DUI checkpoints are not legal because the Rhode Island Supreme Court has said it violates the Rhode Island Constitution. And you can see where that gives us more protection. That is saying that we're going to protect you from the police. We're not going to allow the police to stop you at a DUI checkpoint without suspicion. So we're giving you more protection. So that's allowed. It's given more protection than how the Supreme Court interpreted their constitution. But the reverse is not true. So if the Supreme Court said that DUI checkpoints violate our Fourth Amendment, a state Supreme Court cannot say that, well, it does not violate our Fourth Amendment, so it's okay. Because that now is taking away a right that the federal government gave us. It's not adding to it, which the reverse is, it's taking it away. So states are free to interpret their constitution differently than the federal government, as long as the way they interpret it gives us more rights. Let's take a look at the federal court system really quick. And this is the way the federal court system is set up. We have U.S. district courts, U.S. courts of appeals, and we have the U.S. Supreme Court. As you can see, U.S. district courts, there's 94 districts in this country. And we also have a district bankruptcy court and a U.S. Court of International Trade and U.S. Court of Federal Claims. For testing purposes, just know the number 94, that we have 94 districts. So now we have 50 states. So how can we have 94 districts? Very easy. Some states like California, Texas, very large states, have multiple U.S. district courts, whereas smaller states like Rhode Island and Massachusetts only has one U.S. district court each. And U.S. district courts are the trial courts. So if you commit a federal offense, it goes to U.S. district court. And depending where that offense happened is going to depend on which district court. And then if you don't like that decision in the U.S. district court, we have the U.S. Court of Appeals, and there's 13 of those. Depending on where the district court is going to depend on which circuit it goes to. So it's the appeals court. Circuit courts are the appeals court, the district courts. And finally, we have the Supreme Court, and there's only one of those. So the United States Supreme Court, they can only hear federal constitutional issues. They cannot hear state constitutional issues. And to determine if they're going to hear a case, you file a petition with SCOTUS, stands for Supreme Court of the United States. You file a petition with the SCOTUS. And there's 9 justices on the Supreme Court. 4 of them must agree to hear the case. So we don't need a majority to hear the case. You just need 4 to say, we're going to hear this case. If they agree to that, if 4 justices say, yes, this is a case we're going to hear, then they issue what's called a writ of certiorari. And what that is, in English, is just, it's an order to the lower case to bring it up to them. A writ of certiorari is just telling the lower court, the Court of Appeals, bring us that case. We are going to hear this case. And they hear between 100 and 150 cases a year. And they get thousands of petitions a year, and they only decide to hear between 100 and 150. And how can they hear that many cases? There's only 9 justices. How can they do all that? The reason is because each justice has a whole team of law clerks working for them. And they're the ones that do really the heavy lifting. They sift through the cases and decide which ones to present to the justices to vote on whether to hear the case. So each justice has a whole team of clerks, and that's how they can get through that many cases. So some important terms that you'll need to know, because you're going to be reading cases throughout the semester. So I don't want you presented with terms as you read these cases and not know what they mean. A majority opinion means that at least 5 justices. So there are 9 justices. A majority means that 5. So it's the ruling or the holding of the court, and it's binding nationwide. So whatever federal decision they decide on, that is binding nationwide, a federal issue, and one justice will author it. So a majority opinion wins. A majority wins. Whatever they decide is the law. Then you may see a concurrence opinion. And a concurrence opinion means that we agree, the judge agrees with the majority, but we get there differently. We have a different reason. We both agree on the issue, but we agree for different reasons. And there could be several concurrent opinions. So you'll definitely read cases where you'll see a concurrence opinion, and that's what they mean, is we agree with the holding of the majority, but we just have a different, we got there differently. We have a different reason. And then the dissent is the group of judges that disagree with the majority. It could be 1 or 4. And it's not binding because only the majority opinion is binding. But justices often write dissenting opinions. They want to get their view out there and why they think the majority is wrong. It's not binding, but it can be influential in the future, especially when the court decides to reverse a case like Plessy. They can go to the dissent and say, we now agree with the dissent, what the dissent said back in that case. So dissent opinions are very important. They're not binding, but they are important. Then finally, I don't think we're going to read any per curiam. And per curiam in Latin just means by the court, and it means the author is not named, and it's a non-controversial issue. And we are not going to read any per curiam cases. Finally, there's 2 ways that the Constitution is interpreted. We have originalism view, and we have the living document view. And what the originalism view means, if a Supreme Court justice has an originalism view, that means that whatever the Constitution says, and if we're going to interpret it, we're going to interpret it how the person who wrote it at the time, what they meant at the time. What did the words that they used at the time, what did they mean at the time? We're not going to interpret it as far as what that word means today. We're going to go to the original meaning of what they meant when they used those words. I happen to be an originalist. I think that's the right way to do it because they wrote the Constitution back in the 1700s, and that's what they meant when they wrote it. And then we have the living document view. And people and justices in particular that use the living document view when they interpret things, they say that words change with time. Yeah, that's what they meant back then when they used the word, but today the word means this. So we're going to interpret it on what it means today. And I don't like that, again, because the person who wrote it, that's what they meant at the time. That's what the forefathers meant when they wrote the Constitution at the time. They had no idea of knowing what the word would mean 200 years later. And people, those who are proponents of the living document view say, well, that's not fair because words do change. And I agree, words do change with time, but we have a mechanism and we can change the Constitution. The Constitution is not a document that can't be changed. If we think that words have changed, then I think we should use the mechanisms we have to change the document and use words how they mean today. So those are the 2 ways to interpret the US Constitution. And that is it for chapter 1. A lot of material, and I know a lot of tests that you've only just begun, to be quite honest with you. When we get to chapter 2, there's going to be more that you have to learn. So hopefully you're diligent in your notes. And if you have any questions, please let me know. If you have any trouble with the material, please let me know. And we will we'll have a recording on chapter 2 when we are done with Chapter 1. Thank you.